No, I will not take your civil case on contingency. But let me tell you why, because I think it's going to help you think more about your case and how you might litigate it. May it please the audience, I'm Rich Schoenstein. Welcome to So Sue Me. And I wanted to deal this week with a question I get asked all the time. I get a phone call, somebody has a case, it's a breach of contract case, or it's against a former employer because they think they're owed money or they shouldn't have been fired. And they tell me this great case and they want me to take it on a contingency basis. If you don't know what that is, it simply means that they don't pay for my services unless we win and recover money. And then I get a share of it. And the flip side of the deal usually is you get a big share. You get maybe a third, maybe even 40%, sometimes even more. You get a very big share of the money, but you don't get paid if you don't win. And a lot of people call up and they have cases, interesting cases sometimes, and they want to proceed on a contingency basis. And I say no. Why is that? Well, back up a second. The reason they're asking is because civil litigation is very expensive. Generally speaking, you have to pay lawyers by the hour, and a price for every hour of work, every lawyer who works on your case, every paralegal who works on the case, plus expenses, filing fees, court reporters, copying, legal research charges sometimes, vendors for electronic discovery, expert witnesses if you have experts. All of this stuff adds up, and it's very, very expensive to prosecute a case. And that is why people are asking for them to be taken on a contingency basis. And a lot of people have what they think is a good case. They have a dispute. They think they're owed money, but they don't want to put their own money into it. They don't want to put good money after bad or whatever that expression is. Or quite simply, they don't have the funds to be able to afford a lawyer and the other costs of litigation. So they come looking for a contingency lawyer. Now, contingency lawyers are very popular in certain limited areas. Personal injury and malpractice cases, cases against doctors for things that went wrong in the operating room, slip and fall cases, automobile liability cases. Those have a lot of people willing to take them on a contingency basis. And the way those lawyers operate is they take up a huge inventory of cases so that they know some of them are going to pan out. Some of them are going to settle. Some might go to trial, but enough of them are going to pay off that the whole inventory will be valuable. That works with a personal injury case. It doesn't work with business cases because you can't take enough cases to have that kind of inventory. Consumer class action, security class action, antitrust, these are areas that have highly specialized lawyers who operate on a contingency basis, or they think they're going to apply to the court for payment of legal fees if they prevail. Same thing in employment discrimination cases. If you prevail, you can apply generally to the court for attorney's fees and expenses, so you don't have to charge the individual. Those areas have groups of lawyers who are willing to take on contingency cases and have structured their firms to do so and make it profitable, and more power to them, but not usually in the area of business cases. Let me tell you why. I have 4 reasons that I've come up with why I wouldn't, in most circumstances, take a case on contingency. Number 1, your case stinks. All right. Maybe it doesn't really stink, but I think this is the top reason that lawyers don't accept business cases on a contingency basis. Not everything you think is a good claim is. Not every unfairness in the business world is actionable. You may lose money. You may think somebody else got away with something, but if you don't have a real legal claim, it doesn't amount to anything. Things you were hoping for but didn't get are not necessarily valid legal claims. In the employment arena, you can be fired for all kinds of reasons. Most employees are employees at will, and you can be fired for any reason. Now, if you're discriminated against, you have a potential claim under federal, state, or city law, and you should get an employment discrimination lawyer, and they may be able to take that case on a contingency basis. But if you're just a regular employee who lost a job or who thinks their current job is unfair and wants a big severance package, you don't necessarily have a right to that. So the biggest reason we walk away from contingency cases is we don't think the cases are that good. And we don't always say that because we try not to be rude, but that's the biggest reason. The second reason, you stink. And I mean that in a friendly way. I know you come in with a case, you're overly enthusiastic about it, you think it's the greatest case in the world. Clients are very enthusiastic about their own cases. Some of them embellish, some of them even worse. But also, even if you are earnestly enthusiastic about your case, the probability is that the other side has a point too. The other side has an argument that you haven't considered or aren't taken seriously enough. And it's not just enough to say, I know I was done wrong. I think I should be made whole. Also, when you come looking for contingency lawyers, you are saying, I like my case, but not enough to invest my own money in it. Not enough to spend my money to hire a lawyer. I think my case is great, but I want a free lawyer. That is, unfortunately, a red flag that you may not believe in your case as strongly as you say. And if you don't believe it, if you're not willing to put up money, why should I? Why should I? Now, at the end of the day, your case is only as good as you are. And I can't know if you walk into this office what kind of person you are. I can't know how you're going to hold up on cross-examination. I can't know if you're going to give up the fight somewhere in the middle of the case. And if you go down, the case goes down. So the second reason we don't take a lot of contingency cases is concern about the clients. The third reason is the courts stink. I don't really think the courts stink. I think the courts are great, especially if there are any judges watching. But even if the client is right about something, there may not be evidence. And even if there is evidence, not every judge gets it right. Not every jury gets it right. We've all seen cases go the wrong way just because the decision maker never quite seems to get it. There may be a fundamental wrong, but no legal claim. A lot of complaints are about being fired or like that. But at the end of the day, and the thing that makes this really difficult is at the outset, day one, when you're asking me to take a case on a contingency, I don't have enough information. I can't really know what all the evidence is. You might give me a pile of documents, but I don't know if that's all the evidence. I don't know if the other guy has their own pile of documents. I don't know what all the emails say. I don't know what all the text messages say. I don't know all of the facts and all of the issues. And it makes it really hard to say to you, I'm going to prosecute this case for 2 or 3 years, not charge you a penny unless we win. Really, really hard. And that's because the judicial system is a long, fraught road, and you have to really persevere to get through it to victory. And it's very difficult, and it's sometimes unfair, and it's sometimes a little arbitrary. Next reason not to do it, the other side stinks. And here, I don't necessarily mean that the other side has their own evidence. We already talked about that. The other side believes in their case too. Obviously, they're going to fight and scrap and testify and do everything they can to win. They may even go pay for a lawyer. So they're going to put up a defense. You're not just going to walk all over them. But here's the real point I mean by this. You may have the best case in the history of American jurisprudence. You may have a surefire contract. You are owed millions of dollars. Bing, bam, boom. We're going to win. We're going to win on summary judgment. We don't even have to go to trial. But a $17 gazillion verdict plus punitive damages isn't worth anything if the defendant doesn't have money. If the defendant doesn't have the resources to pay a judgment, then it doesn't matter if you're right. It doesn't matter if you win. So we try to figure that out. We try to look at the defendant. Do they have assets? Is there a way to collect a judgment? Is there insurance that might be involved in this claim? That's a little hard. There's not usually insurance for a breach of contract claim. There are for some torts, but not for breach of contract. So that can be difficult. A lot of times there is no sure avenue to collect a judgment, even if you prevail. And so we can't take the risk of that, the risk that you're right, we're right, we do a great job, we blaze through the courts on a trail of victory, and there's no money at the end of the rainbow. That is one of the key reasons not to take a business case on contingency. Remember those slip and fall cases I mentioned, there's usually insurance involved. Malpractice cases, usually insurance involved. Employment discrimination cases, there's often insurance involved. Those kind of cases where there's a definite way to go for recovery, that's an area for contingency lawyers, not a general business case against your former, uninsured, deadbeat, no asset, put everything in my wife's name business partner. How are we going to get the money? How are we going to get the money? Between not knowing who will win, not knowing if the defendant has assets, the whole thing taking a stupid long time, it's very, very difficult to accept a contingency case and really hard to sustain a practice if you wanted to take a bunch of them. Now, there are some possible workarounds. First of all, some lawyers do take some contingency cases. Even cases where the lawyers pay some of the expenses, you can find lawyers out there who will take a contingency case, a business contingency case here and there. They do exist. Just be careful about the extent of the recovery they're going to retain and what the terms are. There's also something called litigation funding, and we're going to get into that in a separate edition some other day. There are companies now that invest in cases. They need a really strong case, and they're concerned about all the stuff I just mentioned. How strong is the case? Who's the client? Is there an avenue to collect the money if you win? That they're very concerned about. But there are litigation funders who will sometimes put up money. There's also informal litigation funding. Friends and family, pool your money. I mean, you can also try to crowdsource, but probably better to pool it from friends and family who might give you some help. Also, there are a lot of lawyers who will do what's called a mixed contingency, where they won't do the whole thing just based on success, but they'll take a reduced fee in anticipation of some upside at the end of the case. You can negotiate things like that. I've done deals like that myself if the case is strong enough and meets the other requirements, but that way the lawyer knows they're not going to be at a complete loss. If you are looking for a lawyer to take a contingency case, let me give you some suggestions about how to approach it. First of all, information. The more you have, the better. You need to be able to answer all the questions that someone litigating your case would ask you. So think about them ahead of time, come up with the answers. Evidence, documents, collect everything. Partially because the lawyer who's considering your case will want to review it all, but partially it's a show of good faith. If I have a potential client who's collected a broad array of evidence, then I know they've really thought out this claim and that they're prepared to go forward. Also, have information about the defendant's financial condition. Do some homework on your own. Can you find out what their holdings are? Do they own a home? Do they own multiple homes? Do they own businesses? Do they have other significant assets that you can find out about? Bring that information to a potential contingency lawyer. Be willing to take a financial stake. Whatever you can afford, small, medium, or large, but your agreement, your willingness to invest is again a sign of good faith. It gives encouragement to the lawyer that you're asking to take their case, and it gives you incentive to keep working on it. And that's my last piece of advice. Work hard. it is still your case. You may get a lawyer, but you can't just hand over a business dispute and let the lawyer run with it. You have to be involved in putting together, particularly the factual background and all of the relevant evidence. That's your job. Do it and do it well, especially if you want a lawyer to take a case at risk. All right. Thank you for watching or for listening to this podcast. We are off and running now. We've got a few episodes in the book, and we're going to be back with more. I don't know what topics are coming up next yet. As you have seen, sometimes we're taking cases out of the headlines and diving into them, and sometimes we're just doing general legal principles like this one. I just thought it would be interesting to talk about contingency cases. Please like this video, subscribe to it, do all that kind of jazz. I'd appreciate it. Come back next time. For now, we are adjourned.